One more session before coffee break. The topics of health and safety regulations, risk management, and insurance are important in the tower crane industry, whether you're a rental company or a contractor. We've two expert speakers to address these issues. First, Michael Rubin, who's partner with legal firm Goldberg Segalla. Michael's almost 20 years' experience as an attorney and is chairman of the firm's OSHA and Worksite Safety Practice Group. His co-presenter is Billy Smith, Executive Vice President of Claims and Risk Management at NBIS. Billy joined NBIS in 2006 and has 30 years' experience in the crane, rigging and construction industry. He's well known for his experience in risk management, safety awareness, and accident investigations. Please give them a warm welcome. Thank you.
Thank you. Is there a timer?
Thanks everyone so much for coming to this great first annual event, Tower Cranes North America Conference. We're going to talk to you today. We've got 25 minutes, so we're going to jump right into it. We were going to give an OSHA update, but the fact is, since the new administration's come into town over a year ago, there hasn't been much going on. So we're going to jump right into a discussion on contract drafting and the importance of various risk-shifting measures. Here's what we do.
The reason we're shifting a little bit is because of time, but when Michael and I look back at the citations given in the tower crane world, they were very limited, very small. And even though the 1400 rules out for construction and certain things deal with the tower crane construction industry, the number of citations were so limited, it didn't make a lot of sense to talk about and take up that time, although it'll continue to grow. And ANSI, ASME B30.3 is a standard of care for tower cranes. Peter was the chairman that sat there. So OSHA alone, ASME B30.3 in itself is 2 different workshops to comprise a ton of time. So what we decided to do was move to the contractual indemnity and liability side of the industry and move in that direction to help this audience better prepare for the fact of a claim and the resulting litigation that may ensue from it.
So we have an overview of the agenda here. Why is contract drafting important? Just going to pose 2 very simple questions. I don't think you'll be embarrassed what your response is. First off, for starters, who here likes winning? Who here likes losing? No one. Contract provisions often dictate who wins, who loses, or who's in the driver's seat, who's behind the 8 ball. And the thing with contract drafting, oftentimes you only look at your provisions when there's been a dispute. And at that point, it's just simply too late. You're already facing an uphill battle, or you're already in the driver's seat. So it's critical, even if you don't have reason to look at your contract provisions or you don't think you do, to go back and look. And what we're going to talk about, we can't teach indemnity law, in 25 minutes. But there are some critical takeaways you need to know. For example, what state are you doing business in? Every state has a different statute or case law or a combination, and you need to know those guiding principles. We've had adversaries who just have one boilerplate indemnity provision, and they do business in all 50 states or many states. That's a very big error, so you've got to think of these things. You have to be proactive, and again, contract drafting is a primary and very necessary form of risk shifting. Everyone knows everyone's suing everyone. It's just a fact of life. So you need to be prepared. Indemnification. Many of you, I'm sure, know what indemnification is. We've got sophisticated business owners here, those in the insurance industry and others. Simply stated, indemnification transfers risk from one entity to another. If I get sued, another party has to stand in my shoes and take the brunt of it and pay the attorney's fees. How you phrase your indemnity provision in a contract is critical. Additional insured provision. This is another primary risk shifting technique. In any contract, your attorneys will want to know what indemnity provision you have. The follow-up question, right on the heels of that, are you an additional insured on another entity's policy? You may look at the certificate of insurance, may look for the other entity's policy endorsements, and find out if you're an additional insured. I'm going to transfer it over temporarily to Billy to talk about waiver of subrogation.
So we insure in this space. NBIS is an insurance company that just deals with crane rental companies, both mobile cranes and tower cranes. So the keynote speaker talked about insurance in his opening comments, and he talked about risk transferring arguments. And Michael's talking about indemnification and additional insured status. So two ways, right? Bare rental cranes, you should get, as a crane owner, in a bare rental situation, you should get the highest contracted protection you can for renting your piece of equipment bare to some GC or owner that's going to use your tower to build the building. And they will then put their operators on it. You may be held liable for any malfunctions or issues with the crane per se due to anything dealing with maintenance or other schedules, but you shouldn't be obligated to any more than just the rental of the piece of equipment. Operator maintained, different world. So what happens naturally is when you're supplying the crane and the operator to run the crane, then this is where Michael's talking about we have to be careful as to what we do. So you see the indemnity has to be fair, knock for knock. You take care of what you did wrong, I'll take care of what I did wrong. The indemnity provision has to be state-specific in most cases. The GC or the owner is going to ask you for additional insured status in most cases on an O&M, and sometimes a bare rental. You have to negotiate that because you only want limited liability and limited risk for what you're doing. There's also clauses you'll see waiver of subrogation at the bottom. Now the challenge with agreeing to waiving your rights to subrogate is that in the end of any event, you have also contractually obligated yourself not to be allowed to or be able to go back to subrogate anything that you paid for, that you were pulled into this net, this web, right? So you get out of it with zero liability, but your cost of getting there, you can't even try to get back because you waived your rights. So when you agree to waiver of subrogation, you agree to waiver of subrogation against anything. Let me give you another example. If in fact someone damaged your crane or turned your crane over or destroyed your crane on a bare rental and you have agreed to waiver of subrogation, it's going to be real hard to get back all that money because you've waived your rights to go after the person that rented your crane. So be careful of the waiver of subrogation. Next. Additional insured provision. So what do they ask for in this case? As a procurement of insurance, they're going to ask you for additional insured status. In most cases, they'll ask you to be primary, non-contributory, meaning you're up front and you're up first, primary. And in a lot of cases, just because of that language, in an insurance world of excess, meaning above the $1 million primary limit, the excess carrier, because you've agreed to it, is going to want all primaries to what they call exhaust before they get to the excess layers. So if there's 6 subs or 10 subs or 20 subs and you've agreed to primary non-contributory language, they want your $1 million layer, your primary first layer, to be paid across the board before excess carriers kick in. So therefore, all the primary comes in first. The insured contract, that's your contract, that your provision that you have, right, for your insurance company, along with the written agreement that you've agreed to. Back to that waiver of subrogation argument that you've agreed to. Notice of termination of coverage is always in there. But what that says is that they want your insurance company to notify them if coverage is canceled anytime throughout the project. Now, some insurance companies have the ability to do that. Most don't like that because that means we got to stay on par with everything the insured is doing and every job they're doing. And as an obligation, they've tied it to the fact that if we cancel during the job site erection and you have no coverage, it's our obligation to notify with the additional insured certificate, the additional insured status holder, the fact that coverage was canceled. And that's hard to do. The endorsement, not just a certificate of insurance. So here's what happens. Many of you will fill out what we would call, your broker fills out an accord that says there's evidence of insurance. And the insurance can be levels. Million primary, an auto policy, a workers' comp policy, it'll state the limits, and any excess policies. So that's the certificate of insurance they're talking about. What many of them now want you all to do is to endorse them on your policy, right, separate from the certificate of insurance. Because if you read the accord that your broker gives, it says this in no way amends, modifies, or alters the actual insurance agreement that you have. But what they're wanting to do is get around that certificate of insurance, and they want you then to endorse them on the policy to make it more what we call sticky and get more teeth and more bite into your insurance policy. Okay, so that's how the AI provision works in a contract. And like I said, on the bare rental side, you should be getting that if you can negotiate it. On the O&M side, you're probably going to have to give that away because it's your operator running your crane, and they don't want to be liable for what your operator does or does not do right. But when you do that, you have to do it on certain conditions. And Mike and I will talk about the other conditions going forward.
Components of an indemnity clause. Hopefully I didn't lose you at indemnity. Why you need to know the laws in your state and why that's so important is some of this might seem arbitrary. So for example, if you're doing business in New York State and your indemnity provision does not start to the fullest extent permitted by law, or you're in California, you've just lost a major risk-shifting vehicle, which is something called partial contractual indemnity. In some states, if you're at fault at all, you cannot get indemnity from the lower tier party or other entity with whom you contracted. If you have this language up front in your indemnity provision, and you're in New York and California, and you do a host of other things, of course, but if you have this language, you can get partial contractual indemnity. So this is something to take note. And a lot of this speaks to the fact you can have the best indemnity provision in the world. What do you need it to be? Well, you need it to protect your rights and be favorable to you. But even more importantly, you need it to be enforceable. So you can get a great indemnity provision, you have your subcontractor or whomever it is execute the contract, a dispute arises, there's a lawsuit, and you say, hey, I've got this indemnity provision here, we should win. Well, then you've got to look at the case law and see, is it enforceable by a court? If not, you can't rely on it. So again, you need to know the state impact on the language. If you're a crane rental company, expressly name your company as an indemnity. What's that mean? It's just really a fancy way of saying identify yourself in the indemnity provision that you will get indemnity running to you. There may be a contractual provision where the owner, architect, GC, subcontractor is indemnifying them. You would like to negotiate and get your name in there as well. And Billy will talk more about that in a case example we have. But these are issues to be aware of.
And as we move forward in that, how many of you in the audience always see when you sign a written agreement, they say you will indemnify owner, agents, architects, engineers, customers, GC, board of trustees. It's getting to the point where we just had an agreement where there was 37 indemnities listed on the contract for the crane company to go to work. It's absurd. It's getting crazier. But you got to remember, when you do that, you're giving additional insured status to every single 37 entities that are listed, and all you're doing is trying to rent a crane. And by the way, you're not in completed ops mode, right? You're in ongoing operations. So technically, you're only providing a service. You're not even leaving anything behind. You're just filling the Pepsi machine. The bottom line about it is that when you leave the job, you shouldn't be liable for anything that was done prior to. It's not a construction defect argument in our world, right? It's a short-tailed world. It's only while we're there that we should be liable for. And when we leave, we should be relieved of liability. The problem is that they pull us all back again because we were part of setting up something, and it arose out of the fact that we were there. So they pull us back in. So whenever you indemnify this list, what we want to do is put us on the list at some point. We'll talk about that at the end of the slides.
Thanks. Another issue with indemnity clauses, are they broad-based or narrowly tailored? If we get a case come in, one of the first things we do is, in the course of looking and evaluating defenses, we'll look at the indemnity provision, and we'll see, of course, what is the language within. And there's really, you can distinguish provisions on two fronts. Are they broad-based? Are they narrowly tailored? Broad-based will say another party will indemnify us for anything arising out of their work. That's a very broad obligation for a subcontractor to face and to owe indemnity to someone else. Could be narrowly tailored that says it doesn't have to just arise out of your operations, but the lawsuit, claim, whatever it is, dispute, has to arise out of your negligence. So that's something more specific. So really, if you're a potential indemnitor, you may owe indemnity to someone else. You would want the provision to say only if we're at fault would we owe you indemnity. If on the other end, you're the party wants to have an indemnitor indemnify you, you want it broad-based provision so that this other entity is on the hook for mostly anything that arises out of the work. So this is a critical distinction, arising out of or to the extent caused by. State-specific issues. This is where all the fighting happens. If you're an entity and you're partially at fault or fully at fault, solely at fault, can you get indemnity? And every state differs some way, maybe not a material way, but the states differ on the statutes they have, the case law they have, and this is something you really need to know when you're drafting your indemnity provisions. You want to have a strategy and know why you're doing something. It's very simple to get a boilerplate agreement that you've used for 50 years, but if you're in Florida, it really should be drafted one way. If you're doing business in New York, it needs to be drafted a specific way. And the courts will give these provisions a lot more deference if they see, for example, the indemnity provision in Florida refers to a Florida statute within it. It shows that this indemnity provision comports with the law and it's enforceable, or at least you have a better chance of that.
And before we move on, so we understand, there's contributory negligence, right? So I'm liable for what I contributed to the act in a 50-50, 80-20, 70-30, pick the number. Then there's some statutes that say if you're 51% at fault, you're at fault, the other party gets off. There's others that say if you're 1% at fault out of 100, you're liable for the whole thing. It just depends on the state and the regulatory language that exists within that state under the insurance laws and the liability laws and the indemnity laws. So think about it. Contributory is easy, right? You pay for what you do, I'll pay for mine. Some is if you're 51, you got it all. So if I got 49, I'm out. Others, if you're 1% out of 100, you got it all. You're in it. So that's how crazy it is state by state. And that's where your insurance company and the attorneys that are hired in the event of a claim have to really pay attention, not only to the state laws, but to the contracts themselves and what you guys have agreed to.
I want to give one quick example that really drives that point home. If you're in New York State and you have a provision in front that says to the full extent permitted by law, if you're 1% at fault, you get reimbursement, or what's called contractual contribution, effectively, of the 99%. So there's a $1 million claim, you're 1% at fault, you get reimbursed. You only have to pay your percentage share, that 1%. If you don't have those buzzwords in front of your provision, in the indemnity provision, if you're 1% at fault, you bought everything, okay? It's a huge, huge difference just by this seemingly arbitrary language in front of an indemnity provision. And here we have, for example, New York. Many states have this. They have a statute that governs construction contracts and these indemnity provisions. New York has a statute, General Obligations Law, Section 5-3221. Texas has one, Florida has one, California has one. Some states like New York also have cases that further explain that statute and give really additional meaning towards it. So again, you need to be aware of this. I'm going to turn it over to Billy to lead us through a case example.
So you can see in our short time, we have about 5 minutes left. We've covered very little on a very big topic that could go for a lot longer in a lot more detail. But here's a case example, all right? Tower crane company rents a crane to the GC or the owner, which usually is the case, right? The guy building the building or the general contractor in charge is going to put the tower up first because that's what's going to build the building. So in that case, the subcontractor's worker gets injured on the site, sues the owner, the GC, and the tower crane company. That's how we see it, right? You guys have been involved in it. We're involved in it every day with insurance. How can the tower crane company proactively transfer its risk prior to this accident, right? So in the contracted indemnity provision, we expressly named the tower crane company as indemnity. Michael hit it on it earlier. So in the contract between the GC and the owner, we know what? In most cases, operator maintain, we are going to have to put up our crane, and the owner or GC are going to demand of us to indemnify them and name them as additional insured, probably waive our rights of subrogation, probably try to make us primary non-contributory in that case. Got it? That's usually what we see. In a bare rental, you have a little bit more leverage because all you're providing is the equipment. So, let's stay in the operator maintain side as well, and maybe on the bare rental side, because as the keynote speaker said, you want to try to limit your liability and get out of what you could get out of if you didn't do anything wrong. So what we've done at the bottom is this. In the last 6 months, we have negotiated with our insured companies to get what we call a Fairness Act, where we will put up the tower crane and we will man the tower crane, and by obligation, we will have to indemnify and additionally insure the owner of the GC who's renting the crane. But now we're going to work with 25 subcontractors to build that project, who we have no idea who they are. We have no idea if they're qualified or not to signal and or rig the load. But yet, we are what I would call left naked on the project, because once that worker of that sub gets hurt by anything on the end of the hook, they sue the general contractor or the owner, and guess what? The GC and the owner tenders it back to the liability carrier of that subcontractor, because they've agreed to do that. We have also agreed to do that. But in the sense of fairness, if we can get the GC or the owner to say this, I will indemnify you for whatever I do wrong, and I will additionally insure you for any liability lawsuit that comes at you, just like everybody else in the project is going to have to do. But when you subcontract you to the 25 subs, and in that list of indemnities, owner, architect, engineer, general contractor, trustees, board, at the very end of that list, name the tower crane company as an indemnity on your contract with your 25 subs. Here's what happens now. The same thing that guy sued the GC or the owner, it gets tendered back to the carrier of that subcontractor. When they sue the tower crane company, now we have under a contract been listed as an additional insured under the contracted document. Now all of a sudden we have the ability to tender that back as well. You understand where I'm going? It gives us a veil just to send the duty to defend argument. The duty to defend by everybody is broader than the duty to indemnify. So when we get named in a lawsuit and we've given the additional insured status, we have to defend that company as an insured with a reservation of rights. And those in the audience that have seen it, reservation of rights means I'm just going to reserve my rights on indemnity until the facts are known. Then I'll pay the indemnity for what I did, depending on the state I'm in. Okay? But in the tower crane world, what's happened to us for history is we have to give away the farm and the firstborn, and we get nothing in return from the 25 subs. Now, all of a sudden, if we collectively get together and say, look, name us in your list, give us some protections against somebody that got hurt, when I can't see him, I don't know where he's at, I didn't rig it, the rigging failed, all of a sudden I'm sued. Or the signal man told me to lift it, and it had some sway, which all loads do, and when it swayed around, a guy got caught and he got pinched and he got hurt, and who's he going to sue? He's going to sue the crane company, because he can't sue his company. And if he sues the GC, they're going to give it back to his company. So the bottom line is, we together, collectively, in Tower Crane Division, got to be named as an indemnity to everybody that rents us. We'll give you everything you want, but we want to get something in return to be fair. That's kind of the end of it. I think with that, it closes us out. We're down to the last minute. Is that it?
Yeah, that's it. Thank you, everyone. Does anyone have any questions?
Any questions on how to work this out? And by the way, we've been successful in the last 6 months with 3 GCs that have named the tower company as an indemnity with all subs they hire. So it does work. It's not easy, and it does work. And the project manager said, I've never seen this before. I don't understand it. And I said, get used to it, because it's coming across the country. All right? So it's a way to protect our industry from lawsuits that are frivolous. Questions? I think that's it.
You got our slide?
Yeah?
Well,
thank you.
thank you very much. Thank you very much. Thank you. Thanks. Right, we've got a coffee break now. If everyone could be back at 11, please. Thank you.